existing Immigration Act, which is that is what we could
Was
have
amended,
done
yeah.
at that time. So the question would be whether we choose to amend just the CARICOM full free movement legislation, or if we also amend this legislation as well. It's not absolutely necessary, but we have in the past adopted a dual system where we put provisions, for example, with CARICOM skilled nationals in the CARICOM skilled nationals legislation dealing with indefinite stay, and then we also mirrored provisions in the immigration legislation. So the question is, it's open to do the same. That's essentially what I'm saying. Now, if we can move to clause 5, this is the reside and work provision that I mentioned earlier, which codifies what has been done administratively, what is being done administratively.
Sorry, I'll let you speak to this and then I have an observation. Clause 5.
Yes, I mentioned that clause 5 essentially puts into law what was an administrative practice to allow a person to reside and work in Barbados.
This question may not be for you because this may be a matter of policy. But I am, and I have in my notes that I don't understand the basis for the provision, because it seems that we have certain categories under which a person is caused to be in Barbados, right? Either the person is a visitor, so there are different categories. I have never understood what is the category. So there is a permanent resident, which this legislation makes provision for, all of the circumstances under which a person may apply to become a permanent resident. This clause 5 that speaks to the minister may, on application made to the minister in the prescribed form, grant to any person a permit in such form as the minister may approve to reside or to reside and work. This seems to fall outside of everything else the bill says on how a person acquires permanent resident status. So I don't understand the difference between the other provisions of the bill that allow a person to become a permanent resident and this creature called reside and work, which I had actually thought that as a matter of policy, we were setting aside in favor of a more predictable permanent residence regime. Can you say a bit more about that?
Well, Chair, you started off by saying that the question may be better addressed to the policymakers, and I would have to agree with you on that. I think this is one of those that we should.
But what is your, okay, so, but what is your understanding of the purpose of the provision in this legislation?
Just given a general discretion in circumstances that are unknown.
I'm going to ask my colleague to respond on this. Thank you.
Good morning. Yes, this just gives the minister a general discretion, which outside of the law, it just makes it grants it legislative authority for the minister to have a general discretion in circumstances that may arise to exercise what is now done, if one may say in darkness, is brought to light in this legislation. It always existed. It is just now being given legislative authority.
And Chair, I just want to say something on this. Having worked in immigration for 19 years, when this status was introduced, this policy, to my mind, it was that, because at the time, you had immigrant status, it was the only other status you can get. And because the person didn't qualify for immigrant status, and there was a determination that you didn't want to either reject or deport the person, they came up with this, I call it a hybrid, where you're given reside and work. some cases where a person will give a reside, but it's almost impossible to be residing and not working. So this was halfway between not giving the work permit, not giving immigrant status, and you reside and work. And I always felt that once you give a person reside and work, unless they did some criminal act, it was hardly ever going to be likely to revoke that. So it was almost like a two-stage process to get immigrant status. That's all.
So I think that I would like to go on record as saying that I feel as if the move to come up with a more predictable immigration and citizenship regime is to remove the kind of discretionary and murky territory that, to me, this reside and work has always occupied. I don't know what it means. And many people who have been given the status also don't know what it means. They don't know what it empowers them to do. They don't know what are the rights that they have under this. And it seems to me that unless we can hear a valid reason why we would move to modernize the immigration regime and the permanent residence regime and retain this, I do not think it should be retained. It has always been a bit of it has served, I think, to disenfranchise many Barbadians who don't know what status they have, because it's a kind of a hold this until later or hold this because we're not sure. And that's not what law is meant to do. It's meant to give some certainty. Senator?
Thanks, Chair. I do agree with you entirely. But I think the matter is a little bit more nuanced than that. Because when I look now at the several people who we may encounter who have come to Barbados under this, what we call quasi status. It is not a status recognized in law, but this is now trying to put into effect the ability of the state. And I use the state pointedly because I want to also address the continuing use of the exercise of ministerial discretion to determine immigration issues, which are really policy matters that should be guided by law and not necessarily executive or political decisions, because the legislation does not clearly define the bounds for which the minister may or may not be able to act. So that gives the minister a kind of broad discretion to exercise powers outside of the scope determining or the policy of the legislation. I know we have used the Carrollton principle to determine how state powers are exercised, and we continue to draft legislation with the focal point being the minister, but the minister obviously will take advice from the professionals within the departments. But the way the legislation is granted gives the minister, any person who's minister, whether it's one administration or the other, that overriding power for which the scope, which delimits the minister's powers initially coming from Parliament, any legislation doesn't constrain. And unless it is challenged in a court and the court says, look, the minister does not have broad, wide, unfettered powers, and that these powers must be exercised within the context of the policy of the legislation, which means that the court will not have to go examine the policy of the legislation and come up with an interpretation as to whether the minister acted outside the scope of his legislative powers. But I'm asking now, this is no more a drafting question, as to why do we continue to draft legislation in a situation where we may put a minister exercising a valid discretion. Let's say there's a natural disaster in Jamaica, and for humanitarian reasons, we had to relocate or participate in a process of relocating, say, 3,000 children from Jamaica because of a natural disaster. They're not going to qualify under any of the ordinary immigration statuses, the status that exists. So this gives the state the ability to have this category that allows the minister to operate. My query on the policy is that I understand the need for clarification and certainty in relation to how the legislation should be applied and administered. No one should be in a state of uncertainty or a state of contingency as it relates to how the immigration status is in Barbados. No one. But at the same time, we need to also make sure we build in some flexibility to allow us to deal with situations that the law does not actually contemplate beforehand. But should that power be exercised now by a minister? So my first point was in relation to the comments of the chair, but secondly, I want to hear, are we not able to create independent oversight institutions that execute law and policy that does not necessarily involve the overriding ability of the minister to imprint in action something which is limited to his own or her own interpretation as to what their powers are? Because when it says, and there are other parts of the legislation that says that the courts can't even question any determination by the minister. That in of itself seems building in some ring of arbitrariness, ring fencing arbitrariness in the legislation. So this is a policy at the level of drafting. Are we going to move to a situation in this republic where we create autonomous, independent institutions where Parliament passes the law to say what the law is, but these organs of the state must apply the law, and when the law needs to be amended or updated, Parliament does its work? But why the continuing use of the minister, who has to act under advice, but the legislation does not make it clear that the minister can reject the advice and act in accordance with his own or her own discretion? And when that happens, and when we build in here provisions where the courts cannot inquire into the actions of the minister, and this is not limited to matters of security, national security, or anything like that. So Parliament has not limited the extent to which the minister's actions can be inquired by the court, but we're now doubling down on giving a blank check when we should be creating the independent autonomous institutions of the state to execute the policy and laws passed by Parliament. So that is a question I have for why we continue to draft legislation in that way. Thanks.
Thank you, Chair. The issue of whether the minister is used as the functionary or, for example, whether we create an independent body is actually, it's not really just a drafting issue. To a large extent, it is not a drafting issue. Sometimes we are given specific instructions as to who the functionary is. Yes, we admit sometimes, for example, if we're repealing and replacing legislation, sometimes it's accepted that the functionary under the old legislation would continue to be the functionary under the new legislation. Sometimes functionaries are the heads of independent bodies, and that is often a specific policy decision. But I really cannot say that it's just a matter of drafting. What we do observe is that in certain cases, so you mentioned national security, in those matters, we often find that there's more of a tendency for the minister to retain a certain amount of discretion. But again, it is, if we are directed to move in that direction, of course, the drafting office will be happy to comply.
At 13.7 of the existing legislation, which gives the minister really power to grant any citizen at all. And just wonder if that remains one. And I've always held the view that the Minister of Immigration has more power than any other minister in Barbados on the legislation. He's given so much power on the legislation, the point you're making. It was wonder if that 13.7 in the existing legislation if that's carried forward in the current one. Anytime in terms of this one, 27 here, I'm not sure.
I, let me just respond to the comments of Senator Nichols. I do think that I mean, every sovereign nation realizes, acknowledges that there will be circumstances in which emergency powers have to be invoked, national security matters arise, there's a certain level of discretion. I am speaking specifically to the reside and work status that has bedeviled this country for so many years. What is it? What is it? Because if we are, either it is included in the current regime and there is a pathway, there's a category of individuals who qualify in some predictable way. So these are two separate matters. The matter of whether a minister or the state or the cabinet may need to make an individual or ad hoc decision on a certain person's immigration status is one thing. I am speaking specifically to this reside and work creature that was created some time ago that I do not enjoy seeing back here in this legislation. I think it needs to be defined in some ways. We need to understand what is its status, what is it meant for, because we've taken pains to define and demarcate every other issue and every other circumstance in the legislation, but we've just dropped this right back in here. And I am concerned that I'm not sure what it is. Well, how is it different from permanent resident status? Is a permanent resident allowed to work? I'm assuming so. And so if that is the case, why do we have this kind of reside and work? It is amorphous. It is something that, and legislation, the work of legislation is to define and to make clear what the boundaries are. So I don't know if you have another response.
Yes, Madam Chairman. This is taken specifically from the instructions given to the draftsman in the cabinet, in the specific cabinet paper. Paragraph 28 of the cabinet paper, it reads under the heading reside and work. Many persons who apply for permanent residence or immigrant status do not qualify for the same at the time of their application. In the majority of cases, these applicants are persons who entered the country as visitors and resided without any further valid permission from the Immigration Department for a number of years after the expiry of the time granted on entry. If the circumstances merit, they are granted the status of reside and work for an initial 3-year period. However, the existing legislation does not provide for this status in the same language, but it provides for it in words that, and they want to obviously maintain as a matter of policy, and draftsmen work on instructions. And
thank you for that.
Yes,
thank you for that. That helps. But what it also satisfies my concern that it is possible to make clearer the circumstances under which an individual may be granted or may qualify for something called reside and work. As Clause 5 stands now, it is just saying a person may get reside and work. And a person reading this legislation does not understand the circumstances under which they would qualify. So I would suggest that it is possible to make clear in the legislation the circumstances under which a person is eligible for this. Again, it does not take away whatever we recommend with respect to the powers or the discretionary powers of the minister. But specifically on this status, I do think that this Clause 5 as it stands does not provide any more certainty or predictability for this particular status. And I think I would like to submit that we might want to seek to strengthen it to offer a bit more predictability, and that will not take away from the discretionary powers of the minister. I think the genesis of reside and work came from those discretionary powers only. So it was as we just heard, it was a scenario where people were not sure what to do. They didn't want to say no, they couldn't say yes, and so you gave this thing. And this clause does not, to me, it mentions the words, but it doesn't make them give them any more status or strength under the law. And I think that we might be able to improve on that in our recommendations, or make a recommendation for improving on that. Sorry, you wanted to come back in?
Thank you, Chair. Perhaps, well, subject to the policymakers agreeing, perhaps what we can do is create some sort of provisional status based on the person having applied for citizenship or permanent residence, so that they know that there's this category that they fall into. Would that satisfy your concerns?
It could. Thanks. Does anyone wish to speak to Senator Nichols' observation about the discretionary powers of the minister? I mean, even though I acknowledge that this is certainly not the only piece of legislation that does it. Almost all the legislation that I see names the minister with the understanding that the minister must act under the advice, either with the approval of the cabinet or with the advice of their technical teams. I understand that we may want to modernize the general approach to legislation by making it more specific. Certainly, I myself, while in cabinet, have made recommendations for legislation under my own ministry that specified it was the cabinet to make a certain decision and not the minister. That was to protect the minister, quite frankly. So I take the point, but I think it's a broader point. It's a broader point about how we draft legislation in general. I did want to respond to your observation about an independent, autonomous institution of the state. And I want to caution that we not also remove these matters to wholly bureaucratic processes. I think we have to be careful. There have been cases where we have established boards, tribunals, bodies, institutions that have not strengthened the effectiveness, the efficiency, the decision-making, the clarity. They have not. And so I think, while we're considering what we might do in this case, that we have to be aware that simply establishing an institution, especially in a small state like Barbados, need not solve the problem. And in many cases, it moves the discretionary power and the absolute power from the minister to another person, to another individual, a chairperson or some other individual who ultimately has decision-making power. So that may not cure what we are trying to cure. Okay. I think we can.
Just to wrap up, and I do accept that at the end of the day, decisions on immigration have to be made at some level. And so I mean, the buck must stop at the executive. If it doesn't stop at the executive, then what happens? So we must appreciate that there is at the end of the day, when we look at how sovereignty is dissolved in the society, a political decision that has to be made by the people as to whether or not the government of the day is living up to what they consider to be acceptable standards of governance. So that is the political contract that we all subscribe to in our system, that some important decisions should be reserved to the government of the day, and they make their decisions based on whether or not what is in the best interest of the country, and if the country doesn't think that the government is acting, then there's a change of government. So we accept that. So, but I'm just trying to make sure that we don't build into the law an administrative policy that now comes with these undefined, unfettered powers of the minister, which also are now being removed from the purview of even the courts. Yeah.
Thank you, Chair. So we were also discussing the point system for the acquisition of permanent residents. So the point system is based on criteria like age, education, skill, experience, and the person's connection with Barbados, if they are related to someone, if they have Barbadian descent, so to speak. I don't know if anyone would care to comment on that, but I see. It's between section 7 and the 4th schedule.
So at 6, because acquisition of permanent resident status starts at 6.
Oh, yes.
And this is perhaps a question. The 6.1B makes reference to determination to sufficient financial resources. And it isn't clear to me how that determination is made, whether that relies on regulations that are to come, whether that is discretionary, whether it is connected to, I don't see that it can be connected to the monetary amounts listed in the schedule, because those are more fixed amounts, those are more about assets. So this reference to sufficient financial resources to maintain themselves, I know that in other jurisdictions, it can be discretionary. So the immigration officer can ask you how much money you have, and then say, well, I don't think that's enough money. But what is the, how is the determination made of sufficient financial resources here? Do you know?
No. This is squarely a policy issue, but and certainly regulations can assist in clarification. The thing is, there has to be some amount of discretion. If you have one dependent versus if you have 10, obviously more is needed. That's the most I can say about that. The other issue is that the schedule of prohibited persons also prohibits the entry of persons who are likely to be a charge on public funds. So I think we have to look at that. It's linked. We need to look at it from that perspective as well, because if the policy is to permit persons who are charges on public funds, certainly if your resources look as if they're insufficient and you will become a charge on public funds, then we can't say that you, as a retired person, can support your defendants and you have sufficient resources. So I think it's a balancing act that has to be done, but we do take the point that regulations may assist in clarifying, or perhaps an administrative direction.
Yes, because the other thing that we're trying to, I think we have to look at the purpose of the legislation. Again, predictability. So if I am a person retired from another jurisdiction who wants to move to Barbados, I would rather know or have a sense of whatever is the formula being applied, some amount of money per year, and strengthen my application in advance rather than not being sure and then having an application denied. Because the fact is, I think that we want, from my perspective, we want to have a posture of yes in general on this legislation. A posture of yes meaning, we do want you to come. This is not just about policing. This is about the orderly application of an immigration regime, right? So presumably, we do want retired persons who might be able to contribute. What we want to to create an environment in which they understand what is a part of the preparation for making the application. So we want some predictability. We want them to know, okay, look, we're gonna expect that for every year that you're expected to live, that you will have this amount of money, or this, or assets or whatever, to be here. So that's why I'm making the point that we want people to know what they need to have, rather than to just say, well, this is what I have, and have somebody say arbitrarily, no, that's not enough. And still they don't know what they needed to have. So I do think, I don't know if the intent is for it to be linked to the fourth schedule, because that point system does attach points to a certain level of assets. I don't know if that's the intent, but I just thought it was still a bit vague for me.
If I may speak, Madam Chairman, the regulations will be made for generally to carry out the objects and purposes of the Act. The schedule with the point system deal with a different section in the Act itself, but regulations will be made setting out how that provision should work. Because they're so detailed that to put them in the principal Act would make it a bit cumbersome.
Thanks for that, and that was kind of at the top of my question, that I didn't know whether regulations were meant to address that. Yes. But also I do think that in some cases, without the regulations, we are not able to make the appropriate assessment of the legislation. That's a general point, that there are some pieces of legislation that I think should come with regulations, because the regulations, the devil is in the details in some cases, and I think this is one example of that. Okay, enough from me. Sorry, there was another question I had at 6.3, is it? A person who is a permanent resident of Barbados residing in Barbados may make an application in the prescribed form on behalf of a minor child or dependent who is under a disability. This is strange language, but who is under a disability to be registered as a permanent resident. What are the categories of disability, or what are the disabilities that are, is that a matter of regulation as well? Because we've had many conversations about this notion of categories and types of disability that, quite frankly, often become a bit of an uncomfortable conversation, because it's almost as if a person living with a disability has to satisfy the state that their disability is a valid disability. So are we using some objective reference? Are we laying out the categories?
If I may, disability could mean that you're a child under 18. That's a disability in law. Yeah, disability could mean that you're a child under 18 years of age. That's a legal disability. Or you could be disabled to the extent that you cannot speak or think or do anything for yourself. Those are legal disabilities. A person who can look after himself is not under a disability.
I would like to suggest that we either speak to this in the regulations, and Senator, you want to come in? That we either speak to this in the regulations, or we use some objective, some national body's definition of disability. It certainly can't be our own, and it can't be arbitrary. So the question of the assessment of whether a person, quote unquote, can look after themselves also can't be arbitrary. So I think that for this purpose, we really have to be clear with the definition. Senator?
Just to echo your sentiments there, Chair, and to indicate that any definition of disability ought to be informed by the Rights of Persons with Disabilities Bill, and certainly there are international obligations pursuant to the Convention on the Rights of Persons with Disabilities. I complain often about the extent to which legislation is drafted in a particularly ableist way, and I think this presents an opportunity for us to do differently and perhaps to do better. And so I would ask that the department be guided by the Rights of Persons with Disabilities Bill, the National Policy on Disability, and our convention, our international obligations pursuant to the convention.
And then finally at 6, a person who is a direct, 6.4, a person who is a direct descendant of a citizen of Barbados is entitled upon application to the minister in the prescribed form to be registered as a permanent resident. I don't think I saw, and I know this comes up in the citizenship legislation, I don't think I saw a definition of direct descendant. What are we considering direct descendant for the purposes of this cause?
We would have to read agree there is no definition, and perhaps there should be one we accept that we can make a stronger link, but we'd have to read direct descendant in conjunction with what we've done in the citizenship bill as well.
All right, I believe that you had moved on to 7, right? And you were asking for observations or questions on the point system, the grounds for acquisition?
Yes, thank you, Chair. I had moved on to 7 because I was talking generally about the increase in the ways in which a person can become a permanent resident. So forgive me for skipping over 6. And also, too, I didn't want to spend too long on any one point in case members have comments to make. Right, so we're speaking about the point system, and I explained the grounds that the system is captured in the 4th schedule, and essentially is based on things like age, education, skills, financial resources, yes, and Barbadian descent, with age being the younger you are, the higher your points. So the members would have to scrutinize, you should scrutinize the list, of course, to see how it works. Essentially, I think the policy you will see from the list is that the hope is that Barbados would attract able-bodied, well, no, forgive me for saying able-bodied, but working young or youngish persons to work and reside here, forgive the term, and to become permanent residents.
Thank you, CPC. I think, again, the regulations, the fact that at 7.3, for the purposes of this section, the minister may make regulations respecting the method by which points are to be awarded, that puts us at a disadvantage a bit, because we don't know what that system is, and I think that that is material to what we're discussing. I did have a note here about the fact that, about the award of excess points to a dependent who would not ordinarily qualify, which is a bit of a curiosity to me. It is, Maybe I can hear from you about the kind of rationale.
Chair, I would prefer if you address that one to the policymakers. That is squarely a policy matter in terms of how the excess points are awarded. If I may say though, just briefly, I think one has to consider, this is just my observation, that if we take a holistic approach, families might want to stay together. The dependents may not qualify for whatever reason, and so additional points are awarded.
Right. You can tell me if this is the intent of the legislation. If I am seeking permanent residence and I have a dependent, it's implicit in my application, I would think, would be that I have the means to maintain my dependents, whether that is a minor child or, so the notion that a dependent would have to separately qualify, a dependent of a person making an application under this law would have to separately qualify, especially in the case where that dependent is a minor child. A minor child would not even separately be able to make their own application. So why would I need to award my excess points to a dependent? Certainly, it obviously was not meant to apply to a child. But it would seem to me that there must be another kind of provision that can take care of traveling with your dependents. Perhaps we need to turn our minds to it, and perhaps this is what was contemplated under this provision. But it seems to me that the excess of award points, the award of excess points might not be the way to do that. Because I am ascribing to another person an attribute that I have, and that can't be done. So if the attribute is my qualification, I cannot assign the points for my qualification to a dependent because the dependent doesn't have those qualifications. So I honestly find that a curiosity because I don't know how I can ascribe my own attributes to another person.
We take your point, Chair. If you can look at, in terms of the additional points, you would know that the dependent is, in this case, in 7(2). It's a dependent who's over the age of 18 years. So for example, if you came to Barbados, you stayed, you qualify as a permanent resident, your child is not under the, your child is over the age of 18 years, as opposed to if it were under, in which case, I think the first scenario you suggested, where you're coming with your child, you'd want to be sure that obviously your child, who you're taking care of, who's 7 years old, also gets the same status. I think that case is to be distinguished from a case where the person is over the age of 18 years. In which case, the person might be able to come, but the question is whether or not they get the status, then they would have to have the points. So for example, if you've been here for a while, the person is a student, life is going all right, they might wish to stay as a permanent resident. The question is if they've qualified in terms of the points, and this is my understanding of the policy.
Right, except dependent has to count for something under this legislation, right? The fact is that a dependent means something. It means that that person is dependent on my income and my capacity to maintain them. So in that case, all that matters would be my own status and my capacity to qualify, because these people are my dependents. So there can be categories of dependent, a child that has offspring that has reached the age of majority that may still be a student. There can be all kinds of categories and definitions that regulations can make provision for. But I'm saying that I do not see how it is possible to take attributes that cause me to qualify and apply them to another person. And I don't think it is necessary in order for that dependent to have status under the law. There can be another way of making provisions for a dependent to have status under this legislation to be able to move and permanently reside, rather than taking points and just saying, well, you get some of my points. I find that, I mean, I don't want to belabor the point. I don't want this to just be about me saying that I don't like this provision. But I think that there might be a clearer way of giving status to dependents. And I think that our job is to kind of think that through and see whether we might be able to strengthen that. Senator Boyce?
And perhaps this is a consideration for the policymakers more than our colleagues from the drafting department, but is there not, or can we not create a system where an individual has the capacity, bringing a person who qualifies has the capacity to bring a dependent based on their own points? Because I don't know that is entirely necessary to ascribe points, like the chair has been saying, to ascribe points. It just makes the system a little more messy than it needs to be, and it doesn't, the clarity that I think we are searching for here doesn't exist if we contemplate it in the way that we're contemplating it. So perhaps policymakers can consider a system where a dependent has the capacity, a person who qualifies has the capacity to bring a dependent, whether that person is under the age of majority or over the age of majority, that kind of a thing, but not to then ascribe points to them. Yeah.
We take the point. As mentioned, it is a policy issue in terms of how it's dealt with. We observe that even the meaning of dependent, which you mentioned, in this context, it's a little bit different from the meaning of dependent in clause 2. So perhaps it is something that we expect that the policymakers will revisit and guide us accordingly.
Or it may end up just a recommendation of the committee to, to address. Thanks. Okay, I think we can continue.
Thank you, Chair. A lot of what remains is essentially what is in the current legislation. The loss of status of permanent residence in clause 8, there's already provision for that in the current legislation. Right, that's at section 7. I don't know if there are any comments on this point, but essentially the language is almost identical. Except prohibited persons, we were talking about this before, and as I explained, the list has been modernized from what was in the current legislation. It's been modernized a bit. So there isn't much more I can say about this. I can read out for you what's in the schedule, but you can see it for yourself, essentially. Clause 10, entry without a passport. This is standard.
I have a question on this.
Entry without a passport?
Yes.
Okay.
It's just a question of language. Because, okay, a person shall not be permitted to enter Barbados without a passport unless he explains, one day this language will be updated to acknowledge that 50% of us are women. A person shall not be permitted to enter Barbados without a passport unless he explains why he has no passport and establishes his identity and national status to the satisfaction of an immigration officer. I'm questioning the use of passport as against approved travel document, right? Because an approved travel document within certain regimes and into the future may not be a passport. So we may decide that an ID is an approved travel document. And so then this would become irrelevant. Can we possibly make that language a bit more flexible?
The point is taken, and I do think that it is covered in the definition of passport, which includes a travel permit or other document establishing to the satisfaction of an immigration officer the nationality and identity of the person to whom it refers. So we've just used passport to capture the various
I'm
categories.
just looking back at the definition.
So it starts off with passport and then says it includes.
I'm not sure that your definition covers what I am referring to. Passport means a valid passport. Right? So the definition already establishes that it is, I mean, it repeats the word. Referring to the person producing the passport, furnished with a photograph of that person, duly issued to him by the government of a country of which he's a citizen or subject, has not expired and includes a travel permit or other document establishing to the satisfaction of the immigration officer the nationality and identity of the person to whom it refers. I mean, I don't want, I think that in our discussions on final submissions, we might make some recommendations for definitions, but I just wanted to be sure that to the extent that this repeats the word passport, it is not clear to me that this is wide enough to encompass any approved travel document by the jurisdiction. But I mean, it's just a fine point, so we can come back to that.
Thank you, Chair. If you can allow me 1 second just to make a note on this. Right. Clause 11 speaks to the similar subject as in the current legislation, which is that persons may only enter Barbados by sea, at a port of entry. And also that no person may disembark, whether it's an aircraft or a ship, without the consent of an immigration officer. And it's an offense to do so. Okay. Clause 12 speaks to the duty of persons entering Barbados. And essentially covers the same area as Section 11 of the current legislation. It speaks to one presenting oneself before an immigration officer for the purpose of being examined as to whether or not that person may be permitted to enter Barbados. It also speaks, provides for the cases where persons are in transit. And allows for our automated system, or the system which we use now in terms of kiosks, to provide necessary information before actually going to the immigration officer. Right, me. Clause 13 then? Clause 13 makes, imposes an obligation on the master of a vessel to essentially answer truthfully all questions put to him by the immigration officer in relation to passengers and the crew. And I think I had hinted already with respect, as mentioned, advanced passenger information and our obligations to provide this information for security purposes. Already, this is in clause 14. It's nothing, essentially what we do now. Clause 15 speaks to the JRCC providing, sharing the intelligence, the advanced passenger information with intelligence agencies. And JRCC being the Joint Regional Communication Center. That's part of our arrangement within CARICOM. Clause 16 speaks to how the JRCC may use the information. Essentially, the purpose is to ensure that we're in the region better able to monitor criminal, to monitor activity, whether it's travel by air or by sea, to ensure that nothing that appears to be criminal or no criminal deportees, etc., or anything involving criminal activity is going on. It's preventative and also to assist in the detection of crime. Clause 17, again, is in the current legislation, and it makes provisions for for seamen not to be discharged if they're not, that is, a citizen or permanent resident of Barbados, not to be discharged without the consent of the immigration officer. And it's also to ensure that if a person is being discharged, that person will not become a charge on public funds. Clause 18 speaks to how one deals with stowaways, etc. Persons who are not, here we're only talking again about persons who are not citizens or permanent residents of Barbados. And how one, because a person does not really have the right to remain, how one takes custody of the person on the vessel itself. Or if everything is all right, how the magistrate discharges the person. And then we come to part 3 of the bill, which deals with work permits. I'll just pause while you. Okay. Okay. Right. Clause 19 deals with work permits, essentially repeating a lot of what is already in the legislation. The fact that one, apart from the categories, which will of course include the CARICOM skilled nationals and the freely moving nationals now, that one cannot work in Barbados without a work permit. And the other side of that is that a person may not employ another to work without that person, the other person having a work permit. So the offense captures both the employee and potential employer. Clause 20, sorry.
Sorry, would this not also need to clarify the reside and work status as well?
Well, as I was making the presentation on this clause, I made a note of that as well. Yeah. That the discussion on the reside and work also a bit factors into this. Yeah. So when we look at it in more detail, then we will. Yeah. Clause 20 merely provides for the form and the manner in which one applies for a work permit and the fees to be paid, which are usually spoken to in regulations. Clause 21 speaks to how the immigration officer deals with persons who are not permitted to enter Barbados. It speaks to deportation, detention of such persons, etc. And it also makes it clear that the mere fact that a person has been detained in Barbados does not give them any status for obvious reasons. Clause 22 goes into a bit more detail about the deportation orders, the fact that they have to be prescribed, which means prescribed by law, so the forms have to be in regulations. And it ensures that the deportation order does not become invalid merely because there's any lapse of time between when the order is issued and is executed, because obviously it might take some time to locate the person. Excuse me. And I don't think I need to say it, but it is an offense, of course, to contravene a deportation order. Clause 23 provides for revocation of a deportation order. There are cases in which, for example, the law would allow the persons to voluntarily leave the island rather than through a deportation order. So clause 22, for example, says a person whose permission to remain in Barbados has been revoked or who has been served with a deportation order, where the person leaves voluntarily or is removed, the person has to remain outside of Barbados for at least 5 years unless a shorter period is permitted. And I will acknowledge here because it does speak to ministerial discretion. So again, the point is noted. Clause 24.
Is it your understanding that the minister can deport a citizen of Barbados? Sorry, that's not the clause I read actually. Yeah.
At 23, revocation of a deportation order, sorry, I didn't realize we had passed that part. Notwithstanding any other provision of this act, a deportee may, within 24 hours after he is served with the order, make application in writing to the minister for revocation of the order. At 2, when a deportee makes an application referred to in subsection 1, the deportee shall pay a fee of $3,000, which is not refundable. The scenario in which, so I'm just trying to walk through the scenario, which is that there's a deportation order. I am within the jurisdiction still. And within 24 hours of being served, I can object, or I can apply to the minister to revoke. And at the time that I apply, I must pay $3,000. Which, I mean, I can imagine several scenarios in which a person who has been ordered to be deported and who believes they have just cause to remain does not have $3,000. I'm trying to understand the rationale for this fee.
With respect to the financial aspects of any legislation, Chair, this is not something that we can really speak to.
Except to the extent that you are aware of the general application of fines and fees across legislation. And so you are in a position to give us at least some guidance. So there are other fees that obtain under this legislation, right? I'm assuming most of them are set in regulations, but most application fees that with respect to immigration I don't think, rise to the amount of $3,000. Unless, you know, I mean, if I am, for example, if I am a retiree who's making the case that, you know, I want to retire in Barbados, I have plenty of money to live here indefinitely, then I might set the fee to reflect that status, to reflect that category. I understand that. So I might say, look, if you want to live here in your retirement, you pay me $5,000. Because the question is that you have the wherewithal and the resources to live and contribute to the country in which you're asking to retire. A person who is under threat of being deported does not really meet that threshold. So a person who's under threat of being deported could be of any socioeconomic status. But in particular, could be a poor person who's saying, look, I need to stay here and take care of my mother. I need to stay here and I got paid $3,000 within 24 hours. Just to ask the minister to hold on a minute. That bothers me. And this is a general, I'm not asking you to satisfy me, but I'm saying at the very least, the Office of the CPC understands how fees have been applied or are likely to be applied throughout the legislation. And so that's why I'm making the point that this $3,000 seems a little bit beyond the pale. Just a general.
Well, we can make some general observations with respect to fees first, which is that our recommendation is always that fees are commensurate with the service being provided, because it's not a tax, it's a fee. If, in other words, whatever the administrative cost of the action to be taken is, the fee should reflect that. So this is the advice that we give. If the ministry has required this fee of $3,000, it would have had to have been on the understanding that this is what it will take. Now, again, which is why we accept that it is a very short space of time within which to get this money together. We also accept that in a lot of cases, as you rightly said, the persons may be at a disadvantage in terms of getting the funds. If the committee wishes to make a recommendation, in this regard.
Yes, the committee does. Thank you.
Just Chair, quick question. I'm looking at it here. Ordinarily, when a person is given a deportation order, that person must be removed from the country within how much time is there a set time to deport a person after the order has been given? Within 24 hours? Because I'm asking not for you necessarily to answer, because I can see they're getting at least 5 days. The hearing will take 5 days. You have 2 days, you have a day or so to make the appeal, and then it goes to committee, and they're supposed to respond within 72 hours. Yeah, so you have a few days on island. I'm thinking you make your appeal, and this is just a recommendation because, as you said, most persons may not have the $3,000 the next day or immediately. But during the course of the appeal process, they may be able to raise the $3,000, and if granted stay, then in order for that process to continue, then at that point, then is when you pay.
In general, if I don't, again, this is a fee, this is not a fine, right? Now, fines tend to be applied with some immediacy as part of the punitive nature of, so the idea is that you, listen, you have to have this money forthwith, or you have to have this money within a certain time, and if not, you are going to be incarcerated, and that is a part of the application of the fine, the punitive nature of the fine. A fee is a different thing, right? If I unless we are trying to be punitive in the in the application of this fee, but I'm saying if I don't have it now, I'm likely not to have it in 5 days. So the fee to me should not put the individual under pressure to access a service. Even though it is a deportation, I think that what might be happening here, is that we are almost seeing the deportation already as some sort of criminal behavior. So like, if you want to stop this process, you come up with this, because as an administrative fee to me, I don't see how it makes sense to set it at $3,000. So I am querying the amount of time a person has, the 24 hours, but I'm also querying the fee in general. Why is it $3,000 for this service of investigating to see whether a person has made a mistake? First of all, a person may have made a mistake in the deportation order. We have a system in Barbados where non-payment of a fine now then moves the matter into a criminal matter. So if I have a traffic offense and I was meant to pay a fine, and I didn't pay the fine, or the record suggests that I didn't pay the fine, I can be arrested and held, right? So if a mistake was made I may have paid the fine, but your records don't show it, right? Your records don't reflect it. But you can arrest me and carry me to a police station and lock me up until you get it resolved, right? In the case of deportation, it could also be an administrative error. It could be that I had already satisfied whatever requirements I needed to satisfy to not allow the deportation to proceed, but that is not reflected in your records. But I must pay $3,000 for you to go and check and realize that it was an error. And I don't think $3,000 is commensurate with that service, to check a computer and say, oh, Ramel Springer, oh shoot, sorry, you had already submitted the thing that we need. I don't think that it aligns. So So just to say that with respect to your suggestion, it's not just a matter of whether I can accumulate the money, it's whether the fee is reasonable. I don't think it's reasonable in this case. But I think that in general, we'll have an opportunity, again, this is just kind of going through to see And I think we'll have an opportunity to kind of revisit that. I regret that we don't have the regulations because there may be other fees and other matters that similarly, you know, that we have this issue with. I don't know if we can perhaps find out from the minister when the regulations are likely to be ready and whether they're already being drafted. Because regulations for this legislation, regulations are material to how it will be applied, really. But yeah, I was just saying that I object to the fee in general.
Maybe it be a case that the fee is set by the policymakers to prohibit the application, and not necessarily, I shouldn't say the application, but applications that really don't have any merit or that are just made to delay the process and then create administrative challenges. So that every time an application is made to challenge the deportation order, you have to go into this kind of appellate process that is necessarily baked into the legislation, but before any, because I know that some organizations do put these fees in to restrict the nebulous applications that might come into the system were it not for the fee.
You may be right. But I don't think that approach is valid either. You are talking about removing a person from a jurisdiction, right? Under any circumstance. So this is a person who may have lived here for 25 years. A person who has lived here, who may have acquired dependents here, because you're going to acquire dependents, a family member may have gone on disability at that time and so on. You are saying that a minister can issue a deportation order and I have to find $3,000 to pause it and to try and ask a question. I think that what the state needs to do is to become more efficient in its appellate processes, so that it is simply a question of making a search or carrying out certain investigations in a way that is efficient. But don't tell me that I'm going to charge somebody $3,000 to stop people from appealing a decision. I understand that is often why it is done, but that is not appropriate, I suggest. Any other observations?
Just to agree with you, because to the point that a person appealing a deportation order is a person fighting for their lives. Their life is being disrupted, their family's life. So it's not going to be in the same sense where you come with a frivolous appeal. So I get you there. But at the same time, not necessarily saying that 3,000, because I don't have a sense of what it will cost in terms of the actions that will be taken, the administrative costs. And we don't know that. And as you said, we'll wait on the regulations to get a better sense. But there should be some cost. And I think the process is being triggered by the actual deportation order. Then all I was saying was that maybe the costs should come further at the end. If you have a few more days, give the person a chance to, as you said, even though you don't agree, to accumulate funds, to source funds. Some of these may not necessarily know within 24 hours who to turn to for assistance. So you give the person, take it from a human side. Because when a person is given an order, they're panic, they're stressed, they don't know what to do. So as a human being, you give them enough time to catch themselves, to understand their persons or institutions or entities that they can turn to for assistance. All the while, you are going through, the committee have met, they've gone through a number of these appeals, and then they can give a decision within the 72-hour period that is stated here. And in order to get your decision, in order to know if you can stay or if your deportation has been revoked, then you pay at that point. I mean, it's a more human approach. That's what I'm saying.
So, sure, I don't disagree with you on the timing. I'm saying that I also disagree on the fee.
Oh, you pay that. Well, maybe we can discuss the fee
yeah,
further when we get
exactly.
sight of the regulations.
Okay. I think we can proceed.
Thank you. Okay, I believe we were at 25, detention, which speaks to if a person is refused entry to Barbados, the person may be detained, the custody of an immigration officer, police officer, or such other person as may be designated by the chief immigration officer, pending the person's removal from Barbados. Hmm. 25(4) in particular speaks to cases in which a person who might have been detained, let's say the person is detained under a sentence of the court, and who also is a person who could be subject to a deportation order. It provides for the person to, well, essentially, for arrangements to be made for the person's removal from Barbados. Uh, 26 speaks to the recovery of costs of deportation if the person has any assets in Barbados, because they might have been here for a while, they might have assets. There's a provision for the magistrate to levy any property, essentially. Sell property, movable property, so that the cost of the deportation can be recovered. Part 5 speaks generally to administration of the legislation, with the chief immigration officer and the immigration departments on the whole being responsible for administering the legislation. And it provides, clause 27(2) in particular, provides for the powers of the chief immigration officer and other officers in the department. And it provides for searches both with and without a warrant for obvious reasons. Clause 28 speaks to the form in which permits should be issued, whether it's work permits or any other permits. And includes in particular for photographs to be attached and fingerprints. Everything is geared towards identifying the person to whom the permit is issued. Clause 29 provides for evidential matters, particularly how how evidence is to be tendered. It provides for affidavit evidence, for example, if necessary from an immigration officer with respect to records, anything that may be required for the purposes of a matter. Clause 30 speaks to a person being required to produce his permit to an immigration officer, a member of the police service on demand, or at least within 3 days after a demand is made for the permit to be produced. Clause 31, again speaking to the same issue of ministerial authority, provides for the minister to delegate by instrument in writing any power conferred under the Act, except the power to make regulations. To delegate that is to the chief immigration officer. Such delegation, in keeping with ordinary law or ordinary principles of law, will not prevent the minister as a person delegating from exercising that power as well. Part 6 provides for just a few miscellaneous items, including the offenses, certain offenses under the Act. It speaks to things like giving false statement, a person entering Barbados, giving false statements, a master of a vessel permitting a person to be discharged without going through the necessary procedures, for example, ensuring that the person is discharged with the consent of an immigration officer, person is not a charge on public funds, etc. Also speaks to offenses in terms of persons harboring or concealing other persons who are in Barbados in contravention of the act. For example, if the persons stay in Barbados without having legal permission to stay. Also speaks to aiding and abetting, and of course, fabricating, falsifying passports and, well, other documents related to the act. Clause 33 in particular speaks to the offense of smuggling persons. And it includes things like necessary in terms of commission of the offense, like falsifying travel documents, etc. Clause 34 provides a penalty for smuggling, and clause 35 speaks to the right of appeal, which we were discussing in terms of persons being aggrieved by decision of the chief immigration officer having a right to appeal to the minister, who is under an obligation to constitute a committee, which will include not just the minister, but the Solicitor General as well, and a third person determined by the minister to review any decision of the chief immigration officer. And the decision of that committee is final. Clause 36 provides for forfeiture in the, especially in relation to the smuggling of persons, forfeiture of any, essentially, any property of the persons, which would of course be, well, which would usually be proceeds of crime in any event and likely to be forfeited under other legislation as well. 36 also provides for the forfeited assets to be put into the Criminal Assets Recovery Fund, which is a fund that was established some years ago to house proceeds from various crimes, including not just smuggling of persons, but terrorism, corruption, money laundering, crimes of that nature. And clause 37 provides a general penalty because, as you would have realized when you went through the bill, there are some offenses that have been created, but the penalty was not specified in that particular provision. So clause 37 is what provides the penalty in those cases. Clause 38 is our standard regulation making power, which allows the minister to prescribe regulations for all the matters that we discussed, where you saw the word prescribed being used. Those matters, whether it's fees or forms, would come by way of regulations. Chair, you've already mentioned that it would have been helpful to see the regulations, so we accept that. And clause 39, because of course we already have existing legislation, makes provisions for how we treat with matters that are still live, so to speak, under the existing legislation. And it also provides, in relation to the regulations, that the regulations will remain in force. The regulations under the Immigration Act, Cap 190, will remain in force until revoked by regulations under this new legislation. And clause 40 provides for the repeal of the existing act, clause 41 for commencement of this new legislation. We discussed the schedules in different ways. I'm not sure if I don't believe that we spoke to the first schedule, domestic space, which is used. Let me find the clause for you. Okay, it's one of the earlier clauses. Right. Okay, domestic space, that language is used in clause 2, which essentially lists all those countries as, in the first schedule, as comprising our domestic space. So that's, so, and in clause 14.3, where it's relevant, is it relates to when the information, the advanced passenger information, etc., needs to be shared. So if you will look at clause 14.3C, you will see that for a ship arriving from outside our domestic space, it must be no later than 24 hours prior to arrival, so 1 day. Okay, coming back to the schedules now. We spoke to the list of permitted entrants here. In the second schedule, the third schedule concerns the list of EU member states, and we spoke already about the bill incorporating our obligations under the Economic Partnership Agreement between ourselves, the CARICOM member states, and the EU. We spoke as well about the fourth schedule in terms of the point system for persons that attain permanent resident status. We also spoke about the fifth schedule in terms of the list of prohibited persons. And the sixth schedule mainly captures information related to the advanced passengers, the obligations relating to advanced passenger information. It gives a bit more detail as to what is required. And with that, Chair, I believe I've come to the end of my presentation.
Thank you. I think one of the things that we acknowledge is that we really need to understand the regulations that will govern the method by which the points are to be awarded. Otherwise, the first schedule, I feel, doesn't make much sense to us, and is critical to this legislation. And then the fifth schedule makes reference to persons whose conduct offends public morality. What does that mean?
Let me just say that the persons whose conduct offends public morality is already in the legislation. There was clearly a policy intention to keep the provision, whereas certain other provisions in the existing legislation were not kept, but we do accept that it can be a little bit ambiguous to a certain extent, and perhaps a bit subjective. Because but then I don't want to get into very philosophical discussions about what morality is, but certainly, and then if I start to discuss, it might be my subjective view. But for whatever reason, this is one of the provisions that the policymakers preferred to keep.
Right, but in your drafting of it and in your understanding of the law, what does it mean? What does it mean materially? What, in your interpretation?
Well, I would say conduct that the average person in Barbados, because we're talking here about public morality, would deem unacceptable. But the thing about, in terms of our values and norms, etc., the thing is, this is also a changing standard to a certain extent. So what one might have called offensive before, one might say is acceptable now.
our highest court has struck down similar vaguely worded legislation in Guyana. I can't remember the name of the case, but it involves some men who were cross-dressing. And the broad, vague language of the colonial statutes was struck down. So it boggles the mind why we would now reinvent that language in a new piece of legislation, because one of the things that would allow a court to strike down a law as being unconstitutional for its vagueness is because a person must know what aspect about their conduct offends the law. To leave it to the policeman, immigration officer, or some public state official to determine on a level of subjectivity what may or may not be an offense would create now that offense would offend the whole principle of vagueness. And I don't think that we should use broad or vague language in that way. In fact, I'm sure you're aware that the provisions of the legislation that dealt with wandering were struck down by the Privy Council, by the CCJ, following the same Guyanese case, because the offense of wandering wasn't specifically defined in a way that any person could know that if you are doing A or B, this is an offense. And it left it open. So I'm not certain as to why we would invite that to be struck down by a court.
Thanks. This language appears in other legislation, and it is equally problematic where it appears in other legislation. And it has also caused us as a jurisdiction to be unsure about, so for example, there's certain objects that are deemed contraband because they offend public morality. And nobody can say, what is the public harm that these things cause? So I would like to suggest that we not repeat that mistake. This is new legislation. We keep making reference in our discussion to what is already in the law, but this is new legislation, and the point is to improve on the regime. So the notion that, well, it was there before, so we're not going to trouble it, I would like to suggest that we not keep that as a principle. We are trying to, there's certain things that we make a decision that we want to keep because they serve a public purpose. But I think that we should have a general posture that we are creating a new regime. We won't throw out the things that serve us, but we'll certainly recreate the things that we need to recreate. So it's language that I've never been comfortable with, and I don't know what public morality is. So I think that it's something that we might want to consider later or in the course of our deliberations. Any other observations or questions on this legislation before we take a break? If not, thank you kindly, CPC, and I think we will break for 15 minutes. All right, we'll break for 15 minutes. Thank you. Okay, welcome back, everyone. We will resume with review of the citizenship bill. And I'll ask the CPC to similarly take us through and pause for any questions or comments. CPC?
Thank you, Chair. First of all, to summarize, the principal changes made to the, well, sought to be made to the legislation, you would note that the grounds for citizenship have increased. So, for example, citizenship by descent may be extended to great-grandchildren. Citizenship by descent may be extended by either parent. And the bill also provides for application for citizenship after a certain amount of time as a permanent resident. It also aligns the oath of allegiance with the oath in the Constitution, and it provides for the reclamation of citizenship after citizenship is renounced for whatever reason. So to take you through now to the individual clauses of the bill. Well, of course, Clause 1 provides the short title. Clause 2 provides the definitions for the terms used in the bill, and of note in particular would be the definition of child, the definition of dependent, which captures spouses as well as persons who are under the age of 18 years, and persons who are relatives, and they might have reached, they might be older than 18 years, but because of any infirmity of body or mind, any disability, they're wholly dependent on another person for subsistence. I just pause here in case anyone has any questions on Clause 2 before moving on. The definitions, yes. If there's any comment. All right, if not, getting into the heart of the thing, Clause 3 provides the additional grounds on which citizenship may be acquired. And we say additional because, of course, the grounds in the Constitution still apply. So Clause 3.1, for example, replaces the existing Clause 4.1 and speaks to, well, it's just a refinement, really, when you think about it, providing for a newborn infant found abandoned in Barbados to be deemed to have been born in Barbados and therefore entitled to citizenship unless there's evidence to the contrary. Clause 3.2 provides for a person who was born outside Barbados and who is a grandchild or great-grandchild of a citizen of Barbados to apply for citizenship, to apply to be registered as a citizen. All of this is subject to Clause 4, which we'll discuss shortly. Clause 3.3 allows for a person who was granted citizenship, permanent resident status under the current Immigration Act to apply for citizenship as well. Clause 3.4 is essentially a transitional provision in the sense that a person who obtained immigrant status under the former Immigration Act and was in Barbados for a period exceeding 3 years is entitled to register as a citizen upon the commencement of this new legislation. Clause 3.5 it speaks to the forms, the fees, etc., for registration as a citizen. And it covers a lot of what is already in the Barbados Citizenship Act. It speaks to persons who are nationals of a member state, and here member state would refer to the member states of the Caribbean community. By birth, descent, or naturalization, they can apply, as well as the spouse and dependents of such a person, which is consistent with Barbados's obligations under the revised Treaty of Chaguaramas. There are also some periods, some what I would call qualifying periods of stay that are required in certain cases for the granting of citizenship, as you see by clause 3.6. And just also to mention that there are a group of persons who are also entitled upon application to be registered as citizens based on, well, I would say based on their, well, let's go to the schedule. If you look at the schedule, you'll see there a lot of it has to do with the regional nature of the positions the persons would have held. Like, for example, chancellors, former chancellors and vice chancellors of the University of the West Indies, former heads of states, of member states, etc., spouses and dependents of those persons. Clause 4, to which clause 3 is subject, speaks about the right of refusal to register a person as a citizen. And one of the principal considerations is national security and public policy. In the interest of national security and public policy, the minister may refuse to register as a citizen of Barbados a person who, for example, who's been convicted by a competent court, who's engaged in activities within or outside Barbados, which in the opinion of the minister are prejudicial to the safety of Barbados or to the maintenance of law and public order, who doesn't have sufficient means to support himself, which is consistent with the policy in the immigration bill we discussed earlier today. Clause 5 speaks to the registration of minors as citizens. And the application is to be made by the minor's parent or guardian. Clause 5.2 allows the minister in special circumstances to cause any minor to be registered as a citizen of Barbados. Clause 6 speaks to the certificates of registration, which again is similar to what obtains now. Clause 7 speaks to, well, the effect of registration as a citizen, essentially. Once you're registered as a citizen of Barbados, in other words, the person becomes a citizen from the date on which they're registered. So it's more. Part 3 of the bill speaks to the loss of citizenship, and I explained that in this sense, there have been some changes in that a person can now, once a person loses citizenship, they, in certain circumstances, can reclaim citizenship. But let's go first to clause 8, which speaks to the fact that the person can indeed renounce citizenship in certain circumstances, for example, where they intend to become a citizen of a foreign country. And once the minister registers the renunciation, the person ceases to be a citizen from that date, from the date of the registration. The proviso, however, is that in certain circumstances, the minister may withhold registration where, for example, the person intends to become a citizen of a foreign country during any war in which Barbados is engaged. Clause 9 speaks to deprivation of citizenship. For example, if a person provided false information in order to get their citizen, to become registered as a citizen, then their citizenship can be deprived. Then they can be deprived of their citizenship, sorry. Also, if the person commits certain types of offenses, for example, treason, and they haven't received a pardon. Some of the other provisions would include things like what you would relate to war times, for example, if a person traded with the enemy. In other words, it does something that does not show that is contrary to allegiance to Barbados.
Sorry, I was going to hold my, I was going to hold my observations on the legislation to the end because it's quite short. But I just wanted to ask, Clause 9, deprivation of citizenship is retained from the existing legislation? Because it seems quite colonial. Meaning, I mean, I don't know the last time somebody was convicted of high treason. You all will have to advise me. But generally, so a person being convicted in a foreign country of a criminal offense of which the death penalty or a term of imprisonment of not less than 7 years may be imposed is grounds for citizenship to be deprived. So citizenship is, so I'm on this planet floating around unless I am anchored to some sovereign nation, right? So it's no small thing. So I've gone to a foreign country and I've been convicted of a criminal offense of which the death penalty or a term of imprisonment of not less than 7 years, which is quite short, as the jail term goes. On that basis of being convicted in another country of a crime where I have been sentenced to 7 years or more, my citizenship can be stripped. Is that what this is saying? Okay, so can you explain what it's saying?
You mean you're a citizen of Barbados and Barbados can strip your citizen? Are you saying that as a citizen of Barbados, that this is speaking to stripping you of your citizenship?
Perhaps you can just explain deprivation of citizenship as outlined at 9. What is this speaking to? Because perhaps I'm reading it incorrectly.
If you have been granted citizenship of Barbados and you are a citizen of another country and you commit those offenses, yes, but a citizen of Barbados cannot be deprived of his citizenship no matter what he does.
I think there's the drafting style may confuse people because in order to appreciate that, then you have to go to section 2, 3, 4, 5.1 or 5.2 of the Constitution to exclude those persons who are made citizens under those provisions. And then anyone else, this provision applies. So that just is more, I like that phraseology that you use, persons who are granted citizenship, rather than persons who have birthright citizenship, because that would not apply to somebody who was born naturally in Barbados.
Yes, thank you. And to answer your question, yes, it is in the current, a lot of it is in the current legislation. We are not saying that we should not revisit if necessary. We are quite happy to revisit and improve legislation. And with respect to some of the offenses, there are some old laws. We see that happening even in the United States now, not necessarily in the context that one might have anticipated, but the thing is, there's a reason that some of the old laws continue to be used because one never knows. Okay. Clause 10 speaks to deprivation of citizenship of Barbados where a person is deprived of citizenship elsewhere. So for example, if the person is deprived of citizenship in the other country on grounds which are similar to those grounds on which Barbados would have deprived them of citizenship, then the minister may deprive such a person of citizenship as well. And the person does get an opportunity to explain himself. Clause 11 speaks to resumption of citizenship, where, for example, the person has made a declaration to renounce citizenship. They can resume the citizenship where they satisfy the minister that at the time the declaration was made, they were about to become a citizen of another country and they could not have remained a citizen of Barbados and still become a citizen of that country. And also that they had reasonable cause to believe that they would have been deprived of citizenship of that country had they not renounced citizenship of Barbados. Part 4, miscellaneous, speaks to the certificate of citizenship. Provision for the certificate of citizenship being essentially the undoubtable proof that a person is a citizen of Barbados, unless, of course, there was fraud involved or something of that nature. And clause 12, again, speaks to the minister's discretion not being questioned in terms of any reason for granting or refusing an application for citizenship under the legislation and the minister's decision being final. I believe that in relation to the immigration bill, there was some discussion on these issues, so we are mindful of those discussions. Clause 14 speaks to evidence, what is essentially taken as prima facie evidence in certain cases. For example, what's on the record, the notices, the certificates, the oath of allegiance, etc., being received in evidence unless the contrary is proved. Clause 15 provides for the minister to make regulations to give effect to the legislation, including for fees and for the registration, as well as for the cancellation and amendment of certificates, etc. Clause 16 provides for the minister to amend or vary or revoke the first schedule. Clause 17 provides offenses related to the act, for example, giving false, making any false statement. 18 provides for the oath of allegiance, which, as I explained, is now aligned with the oath in the Constitution. clause 19, because the current legislation is being repealed by clause 20. Clause 19 provides a transitional provision to deal with matters that are still live. So for example, any application for the grant of citizenship of Barbados or for registration as a citizen that started under what would be the old legislation then, but was not completed before the commencement of this new legislation, will be deemed to be an application for citizenship under this current legislation. So everything just continues. And clause 20, I spoke to clause 20 already. Clause 21 provides for the legislation to come into effect by proclamation. We went through the list in the first schedule. We looked at the first schedule, and the oath of allegiance is in the second schedule. And that is essentially the bill.
Thanks very much. Questions, comments, observations?
Yeah, of course, I got a question on clause 13. A very unusual clause, and I know that the CPC may tell me that this is part of the drafting instructions that they would have received, but I'm not understanding why a clause like this will pass muster from even a drafter, knowing what courts have said about these kinds of clauses in any event. And I'm not sure if it is taking the form of, it's not outright ouster clause, but it does something more than oust the jurisdiction of the court. It basically says that this is an unfettered power. I can understand why the minister may not be questioned on the determination of citizenship issues, which will concern national interests, not only national security interests. But at least when Parliament gives that power, it should come within the context of a policy that it is being delegated to be administered by Parliament to the minister in a way that Parliament retains some control over the power that is being given. When we talk about the separation of powers, and for Parliament to give up that power and then there is no ability at all, not only is the minister not required to answer, he's not required to give a reason. So that I don't understand the legal or jurisprudential basis for an untrammeled, unfettered ministerial discretion in law. I don't understand it. But I can understand, as I said, if there are national interests or national security interests, which would buttress the administration of this power, it would then give the courts, which are the last bastion of one's protection in a society, the ability to say with deference to the executive, these are macro issues that a judge may not necessarily want to delve into, or if the judge sees this information in private before the parties who are before the court participating in seeing what is the information the state is providing. At the very least, those are some comforts. But the way this clause is drafted, it seems that once Parliament gives up this power, there is no way in which that power can ever be restrained or restricted or controlled. So it is, I know it is a policy issue, but certainly from a drafting standpoint, is this meant to be certainly an immunity provision as opposed to an ouster clause?
Thank you for your comment. To respond, in terms of the discretion given to the minister, when we went through the bill, you would have realized that in certain cases, we did refer to national security interests, etc., public order. So there is some constraint on the power. We take the comments that you've made, and I think it's worth revisiting, certainly. No, but
Sorry to interrupt, but I'm just asking a question in the context of what Senator Nichols just said. So this clause refers to administrative recourse? Because I'm getting I am taking from what Senator Nichols says that it means that that any decision of the minister is not subject to any judicial recourse at all, which I wouldn't imagine is the case. I would think that this relates to any administrative recourse, meaning any civil kind of tribunal but surely any matter could be the subject of judicial review. The lawyers other lawyers and those in CPC's office would have to.
The challenge with this is that currently under the Administrative Justice Act, these issues are not reviewable. So when the act was passed in 1982, the matters under the Immigration Act and Citizenship Act and a number of other things, I think the Defense Act as well, they certainly were exempted, so the courts could not go into a process of judicial review, which is the court exercising a supervisory jurisdiction to make sure that public bodies are acting in accordance with the law, and that decisions taken by public bodies are within the four corners of the law. Those statutes were exempted from judicial review. Now, the way in which the courts have, or I should say recently, have used the wide berth of the Constitution to get around these so-called ouster clauses or immunity clauses has been a welcome fillip to the law, because the right to protection of the law is a constitutional right, and the courts have interpreted that broadly. But my challenge is that we seem now to be in this here doubling down on, at least I will be comfortable where the minister is required at the very least to state what the basis of the determination was if it were to be questioned, if the legality of the minister's actions are being questioned by any citizen or anyone through the courts, and even if the minister had to give redacted information to the court and not necessarily to the other side, where the judge, who is the last bastion of protection for people, will make a determination that in public interest, I don't have to disclose this to the applicant or to the citizen. I am satisfied that the state has made out a case on an application for the grant or refusal of any matter under this act, that the other side does not have to know, or in the national interest, they don't have to know. But you are saying that the minister does not have to give any reason. Now, this lends to potential abuse, which Parliament itself, in giving up this power, because Parliament is the lawmaker, gives this power to a minister. So when it is abused and the minister is acting outside of the law, we already have indicated that this is not a place where you can get judicial review from. So the courts have always said that we will respect the actions of the ministers when they are acting within their lawful province. So this clause would only make sense if it were an ouster clause, if the minister were acting lawfully. But it goes before there, What I mean is that is when the minister is saying, well, this is the reason why he acted. So the court can say, okay, the minister was acting lawfully, that is the end of the process, this matter can't proceed to trial. But it's saying here that the minister is not required to sign any reason. So the courts will be blind. So the courts cannot inquire into the validity of the legality of the minister's actions because the minister does not have to assign any reason for his or her decision. And that is, to my mind, overly balances the powers in the hands of the state. And I will say that from my perspective, this is not speaking about current ministers or how the system is managed, no, but it opens up for potential abuse. And once that abuse becomes manifest, we are seeing things happen in other countries where even the courts are being accused of having a political bias. But we're taking out the courts altogether in a small country where this provision could be misused 10 years from now, where the minister can grant citizenship or even revoke citizenship to persons. And I'm not entirely comfortable with it unless it comes with some statutory provisions which guide how this process of review can be dealt with.
Thank you. We agree with you that despite all of what is said in Clause 13, the courts certainly have found ways to circumvent such provisions as, and we also accept, of course, that the citizenship and immigration fall outside of the administration of justice legislation. So we take the point. Perhaps it is one that we need to revisit.
If I may add something with your permission, I think that these clauses, they've been referred to as ouster clauses. The court has always examined them and precisely what was enunciated. If it's a matter, and in all of these cases, it's a matter of almost a state secret why the minister deprives or takes away citizenship. You go to the court and the public documents will have to be examined by the judge himself, who would not disclose a reason, because the minister cannot disclose a reason if it would be inimical to the interests of the state. And when the courts examine it, then the judge will have to be given the documents so that he himself or herself can review them and agree or disagree. And that is how these things work. Now, whether this provision can be amplified is a matter for further consideration. But that is where the law stands. And I agree with you that that is where the law stands.
So I think Justice Moore even said it more succinctly than I could have said it. But I'm talking about where there is a rogue minister or a rogue administration which will say, I am not going to court because the law says I don't have to assign any reason, and interprets this provision to tell the courts it is none of your business. Now, what Justice Moore is saying is exactly how the system runs with a system that respects the rule of law. So even though the Act may say that the minister's actions can't be inquired into, where there's a question of the constitutionality or the legality of the minister's action and is brought before the courts would do exactly what Justice Moore said. Providing the information, the other side doesn't have to see it. The judge alone will look at it and hand it back to the state and make a determination. But what happens when there is a rogue minister or a rogue administration which says, the Act tells me that I don't have to give a reason, I'm not going to any court?
one last word. Anytime the court makes an order and anybody refuses to obey that order, he can be arrested, taken before the court, and proceeded against for contempt of court and sent to prison.
I think this exchange goes to my question about whether this clause means whether a court is also subject to this clause, which in my mind, it is not. So that's why I was making the distinction between an administrative process. To me, this suggests that a minister is not required as a part of the administration of this, the regular administration of this legislation is not required to provide to the applicant or to any third party in the administrative process a reason, but certainly that a reason must, to the extent that this may appear before the court, a reason must or should be provided. So that's why I was asking the question about whether this, because I cannot imagine a scenario in which an individual can say, a court has made an order for information, and an individual can say, well, no, this tells me that I don't have to answer you. As a separate matter, if we think that this is very strong language with respect to the administrative process, then I think we can review it. But I don't think that this is meant to invalidate the rulings of the court. Are there any other questions, observations? It's a very quiet committee. I have a question that relates to the process for how these two bills hang together, because this citizenship bill is quite short, and it makes reference to a permanent resident being able to apply for citizenship. So it seems to me as if the two are part of this of a process, meaning to say that, and tell me if I'm reading this correctly because I may not be understanding, is that a person who has satisfied the requirements for being a permanent resident and who has achieved that status can then apply for citizenship under certain conditions. Is that, I'm not sure which, I would have to go back and see which clause it is. But that seems to me, yes, please.
I'm just trying to find the provision for you. Right. Clause 3, 3 says, subject to section 4, a person who was granted permanent residence under section 5(2)(c) of the former Immigration Act is entitled upon application to the minister in the prescribed form to be registered as a citizen. That's one.
Can you explain to me what that means?
Okay. Let's pull it up.
Because that would mean that a person who was granted permanent residence under 5(2)(c). Can we just refer to 5(2)(c), please?
Right. I'm pulling up 5(2)(c) as well.
Of the former Immigration Act is entitled is the former Immigration Act?
The current one.
The current Immigration Act?
I believe 52C might be in one of the amendments, so I'm just checking.
I think, what, I'm sorry. What I'm trying to establish here is so what I'm trying to establish at the start of your presentation, you mentioned that this legislation seeks to expand the categories or circumstances under which citizenship may be granted. And so what I'm trying to establish for the purposes of this committee is what those categories or circumstances are, because the legislation as written makes so much reference to other things that, one has to be sure, what we're talking about. So for example, an individual who is at 3-4, any person who on the day immediately preceding the commencement of this act is an immigrant having obtained that status under the Foreign Immigration Act and had been an immigrant for a period exceeding 3 years shall be entitled to be registered as a citizen of Barbados. So a person who had what was formerly known as immigrant status, which was another curiosity under the former law, would would immediately qualify to be registered as a citizen. So I'm trying to establish these categories because I think that there's some things that because the legislation makes reference to other parts of legislation that we're not clear on. So I'm trying to understand the permanent resident path to citizenship. That's what I'm trying to make clear. So I'm trying to understand, under this legislation, it makes reference to the notion that a person who has achieved the status of permanent residence for some period may apply for citizenship. And I'm trying to understand how the two fit together. Because we're remembering that the immigration legislation that is before us also now allows a person to qualify for permanent residence based on this point system. So strictly speaking, a person can then also, on the permanent residence pathway, then also apply for citizenship on the basis of that point system, because it is really just a kind of a 3-year interim period, and then you can become a citizen. And I think that for the purposes of our conversation, we need to understand that pathway, because I'm not sure that I'm clear on that pathway.
Thank you. I am thinking that there might have been a bit of a typographical error here. The 5.2c looks, when we see 2c in brackets, it suggests that it's a subclause, no? Okay. I'll let my colleague explain then.
This is not the, I can't find that amendment among the papers that I have. I have to find the 5.2c that is here is a different, 5.2, it means that there were subsections added to section 5, and one of those subsections is 2C. We don't currently have that before us. So we'd have to review that, find a copy and let you have it. Because
And at clause 3.6, the following persons may, upon application to the minister in the prescribed form and upon payment of the prescribed fee, be registered as citizens of Barbados. A person who is not a national of a member state, the spouse of the person referred to in paragraph A, dependents of the person referred to in paragraph A, if they satisfy the minister that they have lawfully resided in Barbados as permanent residents of Barbados for an aggregate period of at least 270 days during the period of at least 1,095 days immediately preceding the date of application. So it means that under the point system, been granted permanent resident status, and have been living in Barbados under that status for approximately 9 months out of 3 years, immediately preceding the date of application. And on that basis, I can become a citizen.
period is a bit shorter for if the person is a national of a member state, which is what, 5 tries to capture.
Sure, and I'll be frank with you, a national of a member state of CARICOM might as well be a citizen. That I personally, my challenge does not come in the case of CARICOM members. You live in St. Lucia, you live in Barbados, doesn't matter to me. Quite frankly, I think that's the spirit of the revised treaty, and that's how it should be taken. Where I think we have to consider the point system and the basis for the awarding of points to be a permanent resident, that is the pathway to citizenship. So while this is its own legislation, the truth is that, and the reason we're considering the two together is that, strictly speaking, if I, under the point system, which looks at qualifications, age, assets, and under that system, I'm awarded permanent resident status, and then within 3 years, I become a citizen. That is the question that, that we are considering, and that I'm sure others will come and share with us how they feel about that system. Because that is a easily acquired threshold, I think. And I think that the reason that we would want the minister here in our next session is to be able to talk through that kind of policy perspective. But I'll stop there. If there are no other questions or observations on the legislation, I think we can adjourn this particular meeting. I know our agenda suggested that we would consider written presentations and also discuss the scheduling of oral presentations. I would like to suggest, based on representation made by members of the committee, that we defer the consideration of written presentations, but I would like us to discuss before we adjourn the request for oral presentations and their scheduling. If I could ask the clerk and the team. Well, I'd like us to know, so that we can understand how many oral presentations at least how many?
There has been a request only for one oral presentation. Yeah, I thought what I had seen. It wasn't reading. There's only one. that bill. Madam Chair, if we take, there will be four requests for oral presentation. The borough wants to make one. We have the New National Party, and these other two individuals who misunderstood the process. So I would say four. So we can schedule, once the committee agrees, when next, and we will just write the persons.
In our next meeting, we will need to have read and consider the written presentations. And I think we might be able to take oral presentations on that day as well. I would like to suggest that we meet this Friday. I think that this legislation is critical in nature. And I propose that we not delay or prolong the work of the committee in this regard. So if we will be able to meet on Friday, are members available or not available? Silence means consent. So I suggest Friday at 10 a.m. All right.
Know what time in terms of the oral presentation? We need to give them a specific time.
Also, Madam Chair, do you take into consideration notice for those that are giving the oral presentations?
Yeah, I think that what I would suggest that we do is that we reach out to those who first requested, to ask them today if they are available, and then go through the list. And whomever is available, then we schedule. But in any event, I would like us to meet on Friday, even if just to settle the written presentations. Proposing that we start the oral presentations at, I would say, at noon. Yeah. All right, is there any other business that anyone wants to raise? If not, thank you kindly. Could somebody move that we adjourn this meeting? Until
I
Friday
so
at 10?
move.
Until Friday at 10, second? Who seconded?
Second, Madam Chair.
Thank you very much. And we are adjourned. Thanks so much. Have a great afternoon.